We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran and Duran Schultz Law.
Hi, welcome to Legal Assist. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast.
So for today's discussion, we will be talking about who can own lands in the Philippines.
Yes. So, Attorney Wendy, who can own land in the Philippines?
Well, basically the Filipino citizens.
The other way around, foreigners cannot own land, with exceptions. Okay, only Filipinos can own land. So let's expound that a little bit. Because I said also that there is an exception to those strict rule that only Filipinos can own land. So what are these, Attorney Wen?
One is those natural-born Filipino citizens. So when you say natural-born Filipino citizen, these are Filipinos who are born of a Filipino mother and a father. Second one is those who were born prior to January 17 of 1973 of a Filipino mother, and at the time of the reaching majority, which is 21 at that time, they have elected a Filipino citizen.
Yeah, it will also include those that are dual citizens.
Yes.
Or even naturalized Filipinos, so long as they are Filipinos.
Yeah.
How about corporations?
Well, corporations can also own lands in the Philippines provided
Provided it has to be 60% owned by the Filipinos.
40% is the foreign equity.
So other than those that are obviously Filipinos, dual citizen, natural-born Filipinos, naturalized Filipinos, who else can own lands in the Philippines?
Well, there's an exception with that also. Those foreign nationals who have acquired lands or properties in the Philippines through inheritance or succession. So when these foreign citizens, like example, if you have a kid who is a foreign national but he's not a Filipino citizen, and then he acquired a property upon the death of his or her parents who are Filipino citizens, then naturally that property will belong to that particular.
How is that possible if your parent owns the land and that parent is assumed to be a Filipino, because otherwise he wouldn't have been able to buy or own the land, then naturally the child would be a Filipino
citizen? Well, there are instances wherein the parents have already took an allegiance of a foreign citizenship. So both of them are already of foreign nationals. And then at the time of the birth of the child is of foreign citizen and not a Filipino citizen.
Okay, very good. So it will also apply to those families of mixed marriages, and the person that died would be the Filipino. So as an heir, the spouse would be via intestate or testate succession would be an heir to the deceased Filipino spouse. How about former Filipino citizens? Can they own land?
Yes, former Filipino citizen can own land, but there is restrictions. So in cases of residential land, they can own 1,000 square meters in urban area and up to 1 hectare of land in rural. But for business purposes, they can own 5,000 square meters in urban area and up to 3 hectare of land in rural.
So how would you know if the land that you own would be a rural land versus an urban land?
We can differentiate, or we can know whether an area is a rural or an urban if a particular place or if a particular barangay has already a population of more than 5,000 people, or in that barangay there's already an establishment wherein more than 100 employees are already there. So that would be considered as urban. So Metro Manila is considered as an urban already.
Is it possible that you avail of both? For example, you buy tracts of land under the residential, and then you also have a business, and then you've bought 5,000 square meters.
Yes, it's possible because the limitations imposed by the law for the residential and the business, these are under two separate laws. So yes, you can avail.
How will the Registry of Deeds know that you are a former Filipino citizen, and how will it know that you have not exceeded in the square meter restriction?
In order for the Registry of Deeds to know that you are a former natural-born Filipino, you have to submit an affidavit saying that you are a former natural-born Filipino. And then there's actually a format for that one. And then for the purposes of total land holdings, you have to submit also another document, which is the affidavit of total land holdings, that stating there the total amount of area of the land that you have already accumulated.
You mentioned about the rural versus the urban. Can the former Filipino have both? Like, for example, if it's for residential purposes, can that former Filipino have both 1,000 square meters in area for urban and another 1 hectare for rural? The law says or, so you cannot have both. If you choose to buy an urban lot, which is for residential purposes, just 1,000, then you have to stick to that. If you choose to buy a rural lot, which is going to be 1 hectare for residential purposes, then you also stick to that. You cannot mix and match, and then you cannot combine. Also, you can only have a maximum of 2 lots. You can have 1 lot here, 1 lot that, but you can't have, say, 5 lots. And in accumulation, it will become 1 hectare.
So do you mean to say that even if the area does not exceed 1,000, you can only have 2 lots?
Yes. So what if you're a Filipino natural born and you've migrated to the US and you've had the 5-year period for you to be naturalized, and you are contemplating to secure a naturalized US citizenship, but you have, say, 5 lots already, which exceeds both the 1,000 square meters in urban area for residential purposes, and another one exceeds 3,000 hectares for business purposes. What happens to your land once you have been naturalized? And knowing that these lots are already beyond the applicable or allowable square meter for you to be able to hold as a former Filipino citizen?
Well, I have my reservation on that one, because on my end, I think that you are still entitled to have that particular land, notwithstanding that you have already naturalized as a foreign citizen.
Don't you think that would be a circumvention of the law, that you have particularly acquired multiple lots and then in the eventuality you will become a naturalized citizen of another country?
I would think not, because when you say some circumvention, there must be an intention of acquiring a particular lot and violating a particular law at the same time. But at this instance, you have already acquired that lot. You already have a right to that one, and then you just become a citizen of a foreign country or a different one. So it's not really a circumvention, because there's no intention really of violating any particular law.
You may have a point with that, because if you are an heir to a tract of land left behind by a Filipino, then there's no restriction as to the number of square meters. But from my end, I would think it is a law, and it's a continuing obligation for any non-Filipino to comply with what is stated in the law, because the law intends that the land should remain within the hands of the Filipino citizens.
I remember a case about that, wherein the Supreme Court had decided between the spouses, wherein they have already divorced or separated legally, and the husband, who is a foreign citizen, is claiming for the reimbursement with respect to his share that he has funded to their conjugal assets or the conjugal properties.
Which included the lot and the improvement.
And the improvement as well. And then the Supreme Court have decided that since he is a foreigner, he cannot really own a land, which is already a violation of
The
the
Constitution.
Constitution. So even in the equity or with the law, he cannot be reimbursed of whatever expenses that he might have in that owning in the particular land. But he may be reimbursed with respect to the improvement or the house or whatever is building.
Yeah, looking at the decision of the Supreme Court, the ownership of the land is strictly construed in favor of the Filipinos.
Yes.
Because the Supreme Court said that is the difference between a Filipino and a non-Filipino. So if you can't own land in the Philippines, what are your options?
Well, one option is that if you're an investor, you have money, you can enter into a joint venture.
Yes, right. You can have a Filipino partner that would be owning land, and then your joint venture will cover just the improvement because there's no prohibition from the foreigner to own a building.
Yes. And then with that joint venture, you can enjoy the land, but you have to lease it. And also, there's some limitation with the lease.
How long?
It's 25 years of lease and then extendable to another 25 years.
Yes. Which is the usual option of foreigners. So if you're a foreigner, what can you not do?
With respect to the lands,
Ownership of lands in the Philippines. Absolutely do not use a dummy to have or buy your property under their names because there are a lot of complications. There is a concept of going before the courts with clean hands, because if you are part of the illegal activity, you cannot ask help from the court.
and also it is prohibited under the anti-dummy law.
Yes, for the Filipino that is involved in the transaction, he has lent his name just so that the property can be purchased for on behalf of the foreigner. And the Filipino, violating the anti-dummy law, can be prosecuted.
Yes.
All right? Thank you for listening.
Bye.
Bye.